If the Honorable Bench permits, shall we start?
Yeah.
Much obliged, sir. If it pleases your Honorable Bench, I would like to address the bench as your Lordship.
Please.
Sirs,
Much
would be
obliged, your
fine.
Lordship.
Instead of speaking Lordship, sirs, if you address all of us, sir, it would be better. Because we are
Much
trying to
obliged.
implement this practice from the court itself.
Obliged, sir.
I hope
Before start,
it's fine with all of us.
Yeah. Fine, sir.
Parvez?
Yes, Vivek, sir. It suits us well more than lordships.
Yeah, I can understand. Great.
obliged, sir.
Yeah, carry on.
Before starting with the competition, we will have roll call of all the participants present in the courtroom. So, TC 343 Speaker 1,
Present.
TC 343 Speaker 2,
Present.
TC 343 Researcher,
Present.
TC 364 Speaker 1,
Present.
TC 364 Speaker 2,
Yes, ma'am.
TC 364 Researcher.
Present.
All right. Greetings to the Honorable Bench and the participants. I welcome you all to the third Sankhla and Associates National Virtual Moot Court Competition by the Amikus Qriae. It is a matter of great honor to have you all in this courtroom. With the due permission of your Lordship, I would like to enlighten members of both the teams with the rules and regulations of this court.
Please carry on.
Much obliged, sir. The rules and regulations are as follows. Participants are not allowed to leave the meeting until permitted to do so. Participants are required to ensure strong and stable internet connection. The team members are requested to keep their cameras on throughout the session. In case of any technical glitch or an error, participants could be given 2 minutes as relaxation. Then it is upon the discretion of the judge to allow the participant or to continue with the proceedings. Participants are not allowed to make any gesture, speak, or do any unparliamentary actions throughout the proceedings of this court. The participants have to maintain strict court decorum throughout. The participants are not allowed to communicate with members of the opposite team at an individual level, nor are they allowed to disclose their names, institutions' names to the judges, other participants, or anyone from the organizing committee. Now, as each team is given 40 minutes, which includes the time limit for rebuttal, I would like to ask from TC 343 to tell us how they would like to bifurcate their timings between the speakers.
We would like 17 minutes to Speaker 1, 16 minutes to Speaker 2, and 7 minutes for rebuttal.
17 minutes for Speaker 1, 16 minutes for Speaker 2, and 7 for rebuttal. Is that correct?
Yes.
Now, I would like to ask TC 364 to tell us how they would like to bifurcate their timings.
Speaker 1 will be speaking for 19 minutes and so will the Speaker 2, and we are keeping 2 minutes for rebuttal.
19 minutes for Speaker 1, 19 for Speaker 2, and 2 minutes for rebuttal. Is that correct?
Yes, thank you.
All right. Now, if the participants are ready and your Lordship permits, the court shall start with the proceedings.
Yes, please.
Much obliged, sir. The court is in session.
Permission to approach and begin.
Yeah, please. Yes,
We seek permission to refer to the bench as Sir.
yes. Yes.
This is counsel appearing on behalf of the petitioner in the instant case of Obita Roy versus State of Beachtown. This is petitioner, Speaker 1, addressing issues 1 and issues 2, whereas my co-counsel, Speaker 2, will be addressing sub-issue to issue 2 and issue 3. If the bench wishes to hear the facts of the case, may we begin or move past directly to the issues.
Counsel, I have a query. Why have you not approached the High Court under 226?
While the Article 32 and 226 are twin rights with writ petitions to respectively the Supreme Court under 32 and the High Court under 226, these are twin rights. There is no constitutional procedure or mandate laid down which tells a person that they should always approach the High Court under 226 first and 32, the Supreme Court under 32 later.
But
As well,
considering
in
the
this
scope of the High Court having a wider jurisdiction, and that too against a local body, Don't you think that approaching the Supreme Court straight away has created a kind of chaos before us also, that why should we intervene against an action of a local body when your matter is not even a PIL?
Yes, sir. In this case, the discretion lies upon the petitioner whether they want to approach the High Court or the Supreme Court. We have chosen the Supreme Court in light of the fact that there is no such legislation on which such matter is based on. And secondly, the Supreme Court does not have the discretion to refuse the case of fundamental right. And primarily because such a case is based on fundamental right and it has been infringed.
No, I'm talking about an alternative remedy. I'm not talking about an infringement of a fundamental right. Don't you think the High Court is equally competent in case of an infringement of a fundamental right to grant the remedy to you?
Yes, my lord, it is equally competent, but then again, the discretion lies upon the petitioner.
And the discretion lies upon the bench to dismiss the matter also.
But sir, this is a matter of the fundamental right. Now, if you want,
Then convince us how your fundamental rights have been infringed as an individual, and why should we as the Supreme Court take a collective action?
The jurisdiction of the High Court does not oust the jurisdiction of the Supreme Court. And the Supreme Court must entertain such a suit in which a fundamental right has been infringed. There is no procedure by the Constitution.
Do you rely upon any precedent which says that in matters of infringement of fundamental rights, despite the availability of an alternative remedy, you can directly approach the Supreme Court under a writ?
We are relying on the Constitution, sir.
No judgment, no precedents. I think then our present day Supreme Court has not passed any favorable orders in this regard.
See, you will have to segregate your issue to the extent to prove that you could have filed an Article 32 writ petition because Article 226 is available and all the local bodies are amenable to the local jurisdiction of a particular state. So even Supreme Court has in so many judgments have stated and they have dismissed all petitions which were directly filed in Supreme Court, stating that you file your petition before the respective High Court. Before the High Court, because local body, High Court is more competent to look at the issues involved at a local level. So in such a case, how do you segregate that issue in your matter, that this issue which is evolved, it is going to have a sweeping impact on the entire nation. If that is so, then you can,
probably we may hear it.
This is primarily based on 2 points. One is, since there is no excessive legislation upon such a matter that the case is dealing with.
Are we to formulate legislations being the judiciary again?
Yes, the Supreme Court must entertain suits in which a fact of law is there, a point of law. That is why we have approached the Supreme Court. Also, there is no procedure or a mandate upon a petitioner. In fact, Article 226 starts with notwithstanding anything under Article 32, which is why the petitioner has chosen the Supreme Court in this case.
The petitioner cannot choose the jurisdiction. Here you are completely incorrect when you say that I can choose the jurisdiction. For choosing the jurisdiction, the practice has to be seen. The Supreme Court has already held in so many judgments that if suppose any local issues is involved, then in that case you move to the local High Court, the state High Court, which is competent. Then in that case, I think it would be better that we would first understand the issues from the speaker itself. So elaborate on the issues involved in the matter first, and then we'll talk.
Would the bench prefer to hear the facts of the case or to move directly to the issues?
I think we know the facts. If my senior on the bench decides otherwise.
So we can directly move on the issues. Facts we have read.
Issue 1 in this case is whether writ jurisdiction under Article 32 is maintainable, and the counsel for the petitioner pleads yes. The Supreme Court of Hindustan does have the jurisdiction to hear the matter concerning the violation of fundamental right, in this case, namely the violation of Article 19(1)(g) in the instant case. Now, the petitioner files this case under Article 32 of the Constitution of India, and the petitioner's business under the name of Love Gadgets was arbitrarily halted by the state panchayat, which directly infringed upon the fundamental right to trade and commerce of the petitioner. The general principle is that a person whose fundamental right has been infringed has the locus standi to move the Supreme Court under Article 32, for the enforcement of his own right against the state authority. A person whose fundamental right is affected has a standing to file a petition under Article 32. The legal right to be enforced under Article 32 must ordinarily be the right of the petitioner himself. This principle emanates from the theory that remedies and rights are correlative, and therefore only a person whose own right is in jeopardy is entitled to seek a remedy.
So we clarify that this is a matter concerning individual infringement of rights and not a collective PIL to be addressed, right?
This is an individual since according
Go to the High Court. Sorry, not convincing.
So, sir, but then again, there is no mandate upon us constitution.
Mandate, we are to decide that, and we will take all the precedents from 1950 onwards in this regard, and we'll pass a detailed order imposing a heavy cost on you.
Okay.
Don't teach us our mandate. Tell us how your matter is maintainable.
The matter is maintainable as, sir, I'm dictating and I am putting forward. The panchayat authorities serve as self-governing rural local bodies under Article 243B of the Constitution. Now, as local self-governing institutions, they manage local affairs and perform administrative functions. Therefore, being classified as state under Article 12, panchayats can be subjected to judicial review through writ petitions if they infringe upon the fundamental rights. Now, the expression local authorities within Article 12 refers to a unit of local self-government like a municipal committee or a village panchayat as established in Ajit Singh versus State of Punjab and State of Gujarat versus Shantilal Mangaldas, in which the Supreme Court at the first instance entertained such a suit. This is where it came forward that self-government institutions like a municipal committee or explicitly a village panchayat has been entertained by the Supreme Court.
Can you showcase the relevant para of the judgment you are relying upon? Can you ask your researcher to share the screen of the State of Gujarat judgment you have just relied upon?
We have only quoted this thing. I quoted this.
So you have come to the Supreme Court with a copy of the judgment on which
we have a source. Yes, we have a source. It is AIR 1967 Supreme Court.
Share the relevant para, please.
Yes, it is in our compendium. Can we put forward a compendium, sir? Share the screen for compendium.
If my seniors on the bench are comfortable, I think we can allow them to. And if the organizers don't mind it.
If we can share the screen.
Please.
Yes, that's completely all right.
So I would like 1 minute to pull up the compendium.
Please. Until then, your speaker holds on with his arguments. I don't think that we can allow him to proceed further in that case.
If the time could be paused, Court Master.
Why? Wasn't it your prerogative to keep the compendium handy during the course of arguments?
It is handy, Your Honor, but the thing is,
why should the time be paused?
Qualifications?
Time cannot be paused.
Your Lordship, is it visible?
Not till.
Your Lordship, I think
now
it yes, sir.
Counsel, the copy of the judgment pronounced by the Supreme Court is what I want to see on my screen, and not a copy-paste business on a A4 piece of paper.
Do you have a copy from SCC or AIR or Manupatra?
Not at the moment, Your Lordship.
We take down this as an observation. You rely upon a judgment, you don't have a copy of it, you are wasting the judicial time, we may impose a heavy cost.
Permission to begin once again?
Yeah. Your time, your matter.
So, a simple term used in Article 13.2 is law. The basic norm contained in Article 13.2 is that any law inconsistent with the fundamental right is void. Now, the term law in Article 13 has been given a wide connotation so as to include any ordinance, administrative order, bylaw, rule, regulation, notification, custom, or usage having in the territory of Hindustan the force of law. This means that not only a piece of legislation, but any of the things mentioned here can be challenged as infringing a fundamental right. Then, Clause 3A of Article 13 of the Constitution therefore makes it clear that not only law made by the legislature, but also an order or notification which takes away or abridges the fundamental rights conferred by Part 3 of the Constitution would be void, even applicable to delegated legislation as provided to self-governing bodies, as held rightly by the Supreme Court in Union of India versus Colonel L.S.N. Murthy. Accordingly,
Which year, please? Which year was the judgment pronounced? Colonel L.N.S. Murthy?
2012.
Okay.
It is in the footnotes, sir.
Yeah, I know the judgment.
Accordingly, the following has also been held to be law under Article 13, the validity of which can be tested on the touchstone of fundamental rights. The petitioners have done their due diligence to take relevant information in this case. An administrative order or action as per the Supreme Court in the case of Balaji versus State of Mysore, and regulations implemented by a statutory body as established in the case of Road Transport Corporation Patiala versus Mangal Singh. Even so far as rules implemented by a state authority with considerations to prevalent customs and usages as seen in the
What
case
rules
of...
are we challenging here?
We are challenging the administrative action taken by the local state panchayat.
What date has the impugned administrative order been passed in your matter which you are challenging before us? Where
There
is
was
the
no-
impugned annexure under challenge?
Yes, sir, we are challenging this administrative order
Where is it? What order?
within the factual matrix of the
Please refer
proposition.
to the fact sheet. Which order are we challenging?
If sirs can take a look to the Moot proposition itself.
Para number?
1 second. Para number 6 of the Moot proposition. In regards to the administrative action.
Can you read the para, please?
Love Gadgets was shut down by the panchayat, citing that it was illegal to carry with activities of such nature.
Is this an administrative order?
This is an administrative action.
So you say it is an administrative order.
We suppose the order was the action was taken upon an order, but then again we are denying the fact that any order was so passed or in fact informed to the magistrate in this case, which is why the entire case rests upon this fact that principles of natural justice was not adhered to.
Did you approach the complaint mechanism under the Panchayati Raj Act?
Since the Sarpanch of the very Panchayat himself has come quoting this, we had the need to not approach the very thing because a person passing a judgment.
Appellate body, did you approach the appellate body thereafter?
No, we have not approached any appellate body as we did not go to the very first instance because the Sarpanch was the one who passed the order.
No, the Sarpanch is not the appellate body of the Panchayat. There is an appellate body to the Panchayat, which is not controlled by the Sarpanch.
The petitioners have not approached them since it was a violation of fundamental right. They are not the correct body to judge whether it is a violation of fundamental right or not, which is why we have approached the Supreme Court. A fundamental right is very sacrosanct and cannot be judged by a local state authority, which is why we've approached the apex court.
Okay.
We have a threefold argument. The first being unreasonableness. In Micheldowney versus Ford, a decision of the House of Lords, it is a landmark case in a common law system. So,
why are we bound by the common law system anymore?
We are following this rule because it is a landmark decision which put forward that in common law that
is
even
it binding on us?
If you could please.
Is that judgment binding on us? The House of Lords judgment binding?
It is
on
not
us?
binding, but it has an influence effect and carries
Influence
weight.
effect. What do you mean by the term influence effect?
That the court can take into consideration such a point since it is a part of the common law system that has been implemented in an adversarial system followed in India and thus Hindustan.
okay, this influence thing has been defined in the interpretation of statutes anyway?
It has not been defined as far as the petitioner knows.
Then why should we buy your logic after 78 years of independence? Of there being a concept known as influence effect?
In fact, we have quoted this because it is followed up with another judgment from very India itself based on the same principle.
So
This
rely
is the
on that.
principle.
Rely on the Indian Supreme Court judgment then.
Much obliged. In India, the test of unreasonableness is applicable to delegated legislation as well as quasi-judicial functions, both on the basis of general principles of administrative law as well as under fundamental rights such as Article 19 or 14 of the Constitution. Article 14 guarantees equality before the law. It embodies the concept of equality. The courts have interpreted Article 14 as outlawing unreasonableness in administration, and the courts argue that an unreasonable rule or direction denies equality. Thus, a rule or direction which is arbitrary or irrational would not stand the test of Article 14. It is elaborated in state of Madhya Pradesh versus Mahalakshmi Fabric Mills. It is held that a subordinate legislation, order or direction is open to challenge on the ground that it is arbitrary, irrational, confiscatory in nature so as to be violated of Articles 14 and 19(1)(g) explicitly of the Constitution.
What about the restrictions under 19(2) and 19(6)?
The restriction in the restriction in that case talks about a partial restriction, not an absolute restriction.
Let's not talk about a partial, it talks about a reasonable restriction. Please use the right terminology. You are in the Supreme Court.
Much obliged. A reasonable restriction in this case was not adhered to because by the very fact, according to factual matrix, the shop was taken down on the very first instance and eradicated from the public view without a notice, without any inquiry of the same. In fact, the moment such an action was declared to be illegal and a crime, it stepped into the criminal avenues, and the primary investigative agency in criminal avenues is the police. In fact, the panchayat never even approached the police in this case to decide whether such was illegal or not illegal.
That is why we are asking you to go to the High Court. They will pass necessary guidelines, give you appropriate compensation. This is not a matter which involves a consideration of a case of national importance. We understand there may have been some kind of agitation against you. You have been victimized. Don't jump the process of law. That is what we are trying to instill in you.
But my lord, the process, there is no set down process that we must approach the High Court.
There is a concept of alternative remedy being available and the Supreme Court not being burdened with individual matters. There is a concept as far as my knowledge of law goes.
So yet Article 32 is available to everyone, and the fact that the Supreme Court
Yes, we understand that.
Under that only, as provided by the
available to everyone, procedural propriety has to be maintained by all the litigants. So procedural propriety is not maintained here because you have a remedy. First of all, you have a remedy to seek appeal. When an authority has issued an order, you could have filed an appeal before appellate authority. Even under Article 226, if suppose any alternative remedy is available to you, then you cannot file 226 petition before the High Court as well. Because there is a requirement there as well that there is no alternative remedy available to you. And leaving aside that portion, if suppose you want to come to the Supreme Court, then in that case, the local High Court should not be in a position to decide such a matter. But because all these kind of matters can be decided by the local High Court, therefore there is no reason that you move to the Supreme Court directly. So you have to exhibit that for this reason you can move to the Supreme Court directly. When you say that I have a right under Article 32 and this right is so open that I cannot be restricted, that is a wrong precipitation of law that you have said. Okay, I think your time is up. So there is a speaker 2 from your side.
Yes. I request speaker to continue with the sub issue to issue 2 and issues 3.
Mm-hmm.
Provided she can make scissors.
Permission to begin, Your Lordship?
Yeah, please. Why have you not made union a party here? If you have so much problems with the rules, regulation, policies, process, mechanisms, Why is the Union of Hindustan not a party in your matter? Why is just the state of Beachtown a party in your memorial?
Your Lordship, we have mentioned state of Beachtown as a party in the memorial because of the very cause of action arises in the area
So
of
you are
the.
comfortable if we direct the state only to formulate guidelines in a particular jurisdiction?
Your Lordship, as every state has its own Panchayati Raj Act, we have made the state as a party in this matter, because all the governance that follows within the state falls within the own each state
Don't you
specific.
want the act to be not declared as obscene?
Your Lordship, I'll be dealing with that matter in the issue 3.
Union of Hindustan is not a party for that, madam. That is what I am trying to tell you. This matter involves a construction of the constitutional principles. I think we need to implead the union.
Yes, Your Lordship, but we are filing the case against the state, against the panchayat authorities. That is why we have made it a party, and the 292 is a allied issue.
Can the Panchayati Raj body formulate a guideline applicable to the entire state?
Your Lordship, specific to this state, the panchayat has the right to do so, which is why we have made them a party. And the 292 is an allied issue where we are trying to ascertain the legality relating
So I believe this matter is merely restricted to the demolition of your shop and has nothing to do with the interpretation of 292. Courtmaster, take down, this ought to be dismissed. This can't be allowed.
Your Lordship, both are included. We are including raising issue about both the
Then why
matters.
have you not made the union a party?
Because Your Lordship, the violation was imposed against us by the panchayat authority, which is why we have not made them a party.
If you do
which
not
is a
want any
high issue.
interpretation on 292, I am good. I am good entertaining your petition as is. But if you have an issue concerning the applicability of 292, then I will not hear it later. You convince me on you say a yes on one of the points and we proceed further.
Your Lordship, our main contention is against the violation of our right to conduct the business, which was not reasonable. Along with that,
Madam,
we have.
precisely, therefore, we think in our judicial wisdom that the state, through Union of India, Hindustan, should be impleaded as a necessary respondent. A notice is to be served on the learned Solicitor General. He may depute some ASG Sahab to come and justify the stand as to why should there be a change in the law or whether the law is appropriate and we can follow the old tradition and the Ranjit D. Udeshi precedent and everything. And thereafter, if any remedy is left, we will take care of your case. Otherwise, this petition goes away. You tell me.
Your Lordship, in the instant case, the Supreme Court in this matter would set the precedent, which is why we have approached them
We
as a
don't want
nation.
to set a precedent for a panchayat. Please understand. If we have to set up a precedent, that would be for the pan country. Or if not even the pan country, if at all it is for a state, at least it is a union subject. Yes. Schedule 7 पढ़ा नहीं आपने? State कैसे आके जवाब दे देगा?
Yes, Your Lordship. Because of the very fact, we have made it an allied issue. Our main contention is regarding our violation of natural justice and.
The main issue, I don't think. If my senior judges on the bench, I would want your opinion, sirs. Union of India is not a party in their petition.
Inactions of the panchayat taken under the issue.
Go to the statutory appellate body. They will conduct an appeal. If at all required, the matter will be remitted back to the panchayat. Go fight a trial. Get yourself declared innocent. Seek for appropriate compensation. If you think that compensation is not adequate, again appeal. Don't come to the Supreme Court directly because your so-called 32 as an individual has been infringed by a local body which is not at all to be passed an order against, considering that this matter is not a PIL per se.
Your Lordship, by the very virtue of the fact that not only our fundamental right, but also we were deprived of the very principle of natural justice in the instant case, which is why we were not given any opportunity of being heard, and arbitrary action was taken
We will
against.
record all these submissions with the liberty to you to approach the appropriate appellate body.
Your Lordship, the very reason we have. Your Lordship, the very reason we have appeared directly before the Supreme Court is so that we could get a remedy against the violation, complete restriction on our
This
fundamental
is
right.
not a PIL. Yours is an individual matter. Why should we intervene?
Because of the virtue of the fact that our fundamental right violation is there, and because it is a fundamental right violation, it falls within the Article 32, and which is not a discretionary power, and because it is a violation of the fundamental right, which is why we have.
Madam, fundamental right, my learned colleague is saying that you have a remedy under 226 before the Honorable High Court. Do you mean to say that the High Court is not empowered to rule on your fundamental rights being violated or not?
No, Your Lordship, we are not contending that, but the very virtue of the fact that it is a twin right, which is why we have chosen the Supreme Court in this instant matter. And the Apex Court, as a nationwide body, would be a very competent body to decide on this matter as well, Your Lordship.
Without making Union of India a party to your petition?
Your Lordship, the very reason we did not make Union of India party, because our main contention falls within the actions that has come up against the state itself, state of Beachtown.
बेटा अब एक concept समझो, ठीक है? I may be grilling very nicely. My seniors are there to teach me also, but in my limited understanding of law, what I can perceive of your matter is a case where you have been victimized by the action of a local body, and the issues that you have raised before us concerns the constitutional validity and the process and terminologies and formulation of guidelines, etc., considering what is obscene and what is not obscene, without making union a party. Are we a statutory court of appeal? Because otherwise, till the time Union of India does not come and submits its contention, how can we rule or how can we formulate any guideline considering Section 292's applicability in any manner? And if we are to do that ex parte, I believe the Union will be filing a review thereafter. Let us keep it on a non-miscellaneous day. Let a notice of this petition be issued to the learned SG.
Your Lordship, if we can then proceed with the actions taken by the Panchayat itself and not.
That I think we are not competent. I think you should need to approach the statutory appellate authority. एक individual right सुनने लग जाएंगे, this court will be flooded. We need to discard these practices.
Yes, Your Lordship.
You rest your case.
Your Lordship, if you could convince the court about the inactions and the procedure not followed
3 minutes you will speak. I will not interrupt.
Your Lordship, I would like to highlight the issue whether it can be reasonably apprehended that the Panchayat acted with malified intention. Here in this contention, we state that yes, the actions taken by the Panchayat body was in violation of the very principle of natural justice, Your Lordship. In this regard, the principle of natural justice is not only applied to the judicial body or quasi-judicial body, but also administrative body. In the instant case, the authorities did not act fairly, Your Lordship. No intimation was made to Mr. Obito Roy, nor was any notice sent. The very action of taking down of his shop was done arbitrarily, and no opportunity was made to given to Mr. Obito Roy a fair chance of hearing, which is audio altering partem in the instant case, Your Lordship, and an action adversely affecting him was taken without any consideration of his own viewpoint, and without him convincing that why this action should not be taken, which is a gross violation of the natural principle of natural
Mr.
justice.
Obito Roy, how much cost do you want us to impose on you? We have been asking you not to make these arguments.
Your Lordship, we do not want any cost as such. We want any ₹1 as the cost because of the very fact that we are not contending anything regarding the cost of the matter, Your Lordship. We only want the reinstatement of our business because that is our very livelihood in the instant case, Your Lordship.
A cost is a fine imposed on a party for wasting the time and misleading the court. It is not a cost of compensation being accorded to you. So you have to make things very clear in your mind.
Your Lordship, cost regarding, can you please repeat once again?
for wasting the judicial time and misleading this court? How much cost do you want us to impose on you?
Your Lordship, we did not intend to mislead the court in this instant matter, Your Lordship.
Then you withdraw it and please approach the statutory body. We will pass an order that your matter should be heard in a time-bound manner and appropriate orders and compensation must be accorded to you. We understand your individual right may have been infringed. You go and prove it there. You tell them that no notice was served, no show cause was given, no opportunity to vacate the premises was even accorded, a peaceful vacation was not allowed, uncalled for demolition of the property has happened. You go and convince them. Fair enough. Vis-a-vis your argument on 292, we are not going to have it because union is not here. And in absentia of the union, I don't think such an argument can be allowed to be even placed. My senior has to speak something, so I'll mute myself.
Yeah, in the meantime, your researcher could have done some research on whether the subject matter would fall under the estate list or the concurrent list or the union list. Did your researcher did that research or not?
Your Lordship, if I may.
Mm-hmm.
Lordship, I was just looking into that.
Mm-hmm. So did you find the answer?
I'm currently finding, Your Lordship.
Because that will support you. But at the same time, to the extent, see, upon examination, the subject matter would fall under the estate list. So once it is falling under the estate list, then in that case, union would not be a necessary party, as my friend had suggested. If it would have been falling in the union list, so I stand corrected here. It is falling. The subject matter is falling under the union, under the state list, as item 5 of the state list. So therefore, the writ petition could have been maintainable in the absence of Union of India, but at the same time, it is not maintainable before the Supreme Court, because the same matter can be decided by the High Court, and High Court is having the competent jurisdiction to decide on the similar matter. And also, the part reason is this. The second reason is there is an appellate authority provided under any action taken by the Panchayat. So when there is an appellate authority, even the High Court is divested of the jurisdiction because there is an alternative remedy. So you will have to exercise alternative remedy. So High Court and Supreme Court, going to the Supreme Court when a matter can be decided by the High Court is not, permissible in law. And similarly, if suppose any appellate authority is provided against an action, then you file an appeal, whether it is a question of fundamental right, individual right, or whatever right. The appellate authority has to decide on facts and applying the law. So that is the procedural propriety that all the litigants and the counsels have to maintain. You understand all this point?
Yes, Your Lordship. Your Lordship, if you can insist on continuing with the first issue. The issue that is sub-issue.
We have heard you. You can come in the rebuttal now. It is not necessary that you exhaust your time. We have understood means your approach. We have understood how you have fared in this. Now we can hear the team too.
Much obliged, Your Lordship.
All the very best.
Good afternoon. If I may seek permission to begin. The counsel seeks permission to approach the dais.
Please proceed.
The counsel seeks permission with her pleadings as your lordships and honorable bench collectively.
Who are you appearing on behalf of?
Your lordship, you're appearing on behalf of Union of India.
Is what
But
Union is not a party to the petition.
Your lordship, if I may put this point forward, it is that in the council has made the union a party because in the moot proposition and the factual matrix, it is clearly mentioned that when the petitioner approached the Supreme Court, he claimed that his fundamental right has been infringed repeatedly.
So how
And
that would make union a party?
Even a state can breach the fundamental right. Union is not a party here.
if I may come to that, according to the factual matrix, his fundamental right has once, according to what he claims, it's been once infringed in the state of Madhyasthan, and second, it has been infringed in the allegedly infringed in the state of Beachtown. And when he met, apologies.
Yeah, please continue. Please continue.
Much obliged, Your Lordship. So when the petitioner mentioned that his fundamental right under Article 19(1)(g) has been infringed, he also attached the word repeatedly. So our inference of the word repeatedly inferred that his fundamental right has been infringed in two different states. And when he approached the Supreme Court under Article 32 as the writ petition, we thought it would be most appropriate to make the Union of India a party, as Article 32 was challenged in front
You
of the
being the respondent thought it would be appropriate to make you a party.
Your Lordship.
Would respondent make himself a party, or the petitioner would make respondent a party?
Your Lordship, the petitioner would make the respondent a party.
So are you trying to implead on behalf of Union of India in this petition?
Yes, Your Lordship, we are trying to implead on
Where is
behalf.
your impleadment application on record? You have submitted a memorial that does not talk about your impleadment into this matter. And vis-a-vis the Madhyasthan matter, he was convicted 10 years back. He was released thereafter, post serving the conviction. He opened a new shop. This time in Beachtown. So his infringement of fundamental right is qua the state of Beachtown. So how have you inferred that since his rights have been infringed in two different states, therefore this is a matter concerning national importance, and therefore you as the government of India should intervene?
Your Lordship, we are not saying that it's a matter concerning the national importance. The
Achha, it is
fact
not.
that the clarification, when asked by the council to the organization, was silent about this aspect. And all the if the council may put this point forward, even though it's a little inappropriate for the basis of this argument.
Yeah.
We have had, Your Lordship, we have had several rounds till we came to the finals, and all the rounds had the Union of India as a party. And it is the opposition's own mistake that they made the state of Beachtown the party.
I think you have placed them there. It is your time to be grilled. But if they have not made you a party, how can we allow you to proceed with your arguments? When on record, you have not even filed for an impleadment. See, there are certain moot court rules. I am not disputing them, but then there are certain rules of proportionality and practicality also.
Your Lordships, I agree with what you're trying to put forward here, but as it's very clear that we interpreted the word repeatedly in the
Wrong
context.
interpretation, counsel.
Much apologies.
Is anybody appearing for the states concerned?
Your Lordship, I couldn't catch.
Is anybody appearing for the state concerned here?
Your Lordship, no. Me and my co-counsel are
SG Saab has a lot of matters lined up in other courts. We will not burden the Union of India with the pendency of this matter. We discharge Union and we dismiss your so-called impleadment also. We don't think this is a matter for you to be impleaded. Because 292, if they have not, they have a twin fold of violation. उनकी पिटीशन को पढ़ के, मूट प्रॉब्लम को पढ़ के दो चीज समझ में आती है कि एक तो स्टेट ने दुकान बंद कर दी, और दूसरा इस एक्शन को चैलेंज करते हुए वो 292 में ऑब्सोलिटी का एक डेफिनेशन चाहते हैं, जिस लिमिटेड पर्पस के लिए यूनियन हैड टू कम एंड रिस्पॉन्ड टू. व्हेन दे हैव योर themselves not made you a party, why do you wish to respond to them?
Your Lordship, apologies on the council's behalf.
No,
we weren't
we
aware of this.
I agree. Not required. We discharge the union from making effective arguments in the matter, considering the fact that the petitioners have not arrayed the union as a party, and on hearing the arguments of the petitioner, this court is also convinced that the union should not be made a party.
Mr. Counsel for Union, can you enlighten the court as to is this petition maintainable under 32 before this honorable court?
Yes, Your Lordship. Your Lordship, the counsel for the respondents would like to bring forth the fact that the issue of maintainability for the writ petition, the present writ petition is not maintainable. This is because there were alternate remedies which were available to the petitioners, which he could enable before approaching the Supreme Court. The alternate remedies were approaching
argument in your submissions.
Your Lordships.
Alternative remedy submission. Where have you taken in your submissions? Submission.
Your Lordships, this aspect has not been taken up in our submissions.
Okay.
But as this point,
I just needed to clarify. I saw the submission note because it was not mentioned from that. You took the cue from us. Well, continue, please.
As alternate remedies were available under Article 226, and this is a very private matter. This is no matter of public importance. The petitioner should have approached the state authorities and the High Court before coming to the Supreme Court. This is...
Counsel, I would want you to call the double AG for the state of Beachtown. We will want these arguments from him, please. I don't think you are competent to make this argument. ठीक है, मैं समझता हूँ एज अ वकील आपको बहुत महत्वाकांक्षाएं हैं जीवन में, आप आर्ग्यू करना चाहती हैं कोर्ट के आगे, बट जॉइंटर, मिस जॉइंटर, नॉन जॉइंटर ऑफ पार्टीज भी एक सीपीसी का कॉन्सेप्ट है.
Your Lordship, while I understand what point you're trying to put forward, I would still like to request you if you could hear this case on the basis of its merits and the facts.
And the Supreme Court में 70-80 हजार मैटर का पेंडेंसी चल रहा है, लाखों के ऊपर चल गया. My Chief Justice is after us. We need to complete all the pendency. Why should we hear an uncalled for matter?
Your Lordship, sir, why should the respondents should be blamed for the incorrectness of the petitioners? It was their own mistake labeling the Beachtown as a party. And why should we be responsible for that?
You are not being held responsible. We say that we don't want these arguments from you. Legally, you are winning it.
Your Lordship, but if you could just hear for 5 minutes.
Okay, fine.
Please, much obliged.
Madam, if we are to dismiss this petition with costs, what is the cause remaining for the Union of India to even argue for a minute?
Your Lordship, what we are trying to argue here, if your Lordships are not wanting to hear this matter any further, the council would not elaborate on this any further, but it was just a simple request on behalf of the council for the honorable bench to spare few minutes to hear this.
Please proceed.
Much obliged. The first council will be dealing with the first issue, which is whether the sale of sex toys is obscene. And my co-counsel will be dealing with the second issue, which is whether the writ petition regarding the closing down of the petitioner's shop was violative of his fundamental right under 19 clause 1 subclause G or not. I will be dividing this issue into a threefold argument.
So prior to that, what position do you represent with the Ministry of Law and Justice?
Your Lordship, I didn't catch that.
What position has the Ministry of Law and Justice appointed you to represent them in this matter?
Your Lordship, the factual matrix is silent about that. And as per the rules of this moot court, we are not to assume anything which is not mentioned.
So you are appearing for the union without knowing the position that union has appointed you upon?
Your Lordship, this same question was asked in the clarifications, but the organization failed to provide us with an apt answer. So...
Because such things are to be presumed, right?
Your Lordship, we are to presume nothing except what is explicitly mentioned. If this was to be presumed...
I was myself a mooter. I have done 11-12 moot courts during my law school 10 years back. I used to do international moot court competitions as well. I think there is a extent to which presumption is allowed.
Your Lordship, presumption is allowed to the extent, but not to the extent relating to the jurisdiction of a matter. And that
we are not talking about the jurisdiction here. We are talking about your position with the Ministry of Law and Justice, which enables you to appear on behalf of Union of Hindustan in this matter before us.
Your Lordship, if it pleases the court, the council would prefer to take the position of the Attorney General.
Prefer matlab?
Would take the position of the Attorney General.
Has there been an appointment in this regard of yours?
No, Your Lordship, there has been no appointment in this regard.
But
as you just mentioned, I am to assume and presume.
Fair enough.
And I am to...
What article does your office is defined in?
Let us assume that she is ASG. Let us assume that she is ASG. You complete your arguments. Let us hear what she has to present. Huh?
Much obliged.
Okay,
The first limb of the argument put forward by the council is that the sale of sex toys is to be considered obscene under section 292 of IPC. The second limb is that it is also to be considered obscene using the various tests the court has employed to determine obscenity of products. The third and the final limb pertains to whether the established tests are successful in proving the obscenity of products. And the council would like to come back to the question the Honorable Court asked before. The Attorney General is defined under Article 76 of the Indian Constitution, and that is the authority through which the council is approaching this Honorable Court.
But I think you were just given the designation of an ASG by my learned senior.
Your Lordship, I'm just answering the question that you put forward before.
leave that question. You don't need to answer everything. Okay? Leave that part.
Much obliged.
Proceed.
The council would like to request your lordships to kindly refer to page 1 onwards from the memorial from the respondent side for a very detailed understanding.
Can somebody share the screen?
Yes, I would request my researcher to kindly share the screen. While she is sharing the screen, I would continue with my arguments. Section 292 of the Hindustan Penal Code deals with obscene products. It prohibits and prevents the sale, distribution, or any sort of public exhibition of any good which is characterized as obscene. The object is classified as obscene if it is lascivious or appeals to the prurient interest, or it has effects which can deprave or corrupt the mind of an individual whose hands it falls in. This section only considers things which are obscene which harm the morals of the general public. While dealing with cases under section 292 of IPC, it is very important to verify the interest of the society in which it is being sold. The council would also like to request your lordships to refer to page number 2, paragraph 6 of the memorial from the respondent side, and thus like to direct their attention to the fact that the Honorable Supreme Court has previously held in the case of Qriae Abbas versus Union of India that when examining an obscene matter, the whole setting has to be considered, and the obscenity of the product has the potential to corrupt the minds. Specifically,
What's the citation for Qriae Abbas?
I would now request that is the citation, but if your lordships would like the official judgment, I would...
No, I just want to know the citation of Qriae Abbas.
In this...
1970.
Yes,
Don't you think the jurisprudence has shifted since then?
Your lordships, the jurisprudence has shifted, but this particular aspect of what the community we are dealing with, which again...
Let us talk about Avik Sarkar.
That is my second issue, which is the community standards test.
Then
which
it will come to that.
Okay, lordship, much obliged. So in the Avik Sarkar case, the community standards test was put forward and the Hicklin's test was rejected by the Honorable Supreme Court. While looking at a present case at hand, this raises a very pertinent question whether the sale of sex toys by the petitioner would cause obscenity under the community standards test.
So what was the Hickling test? What was the Hickling test, counsel?
Your lordship, the Hickling test specified that the considered obscene by individually by a specific number of people, not taking into account the whole community at large and all the factors which are affecting it. This was the Hicklin's test was followed in UK, but when it was applied to the Indian context, it did not follow because of India's various community differences between the other states, and because it has very diverse communities. This is why the Indians...
ask you, where is obscenity defined? What is your response going to be?
Your lordships, obscenity is not defined, but we have used the definition of the Black's Law Dictionary while
Obscenity
defining...
is not defined.
It's defined under section 292 of the IPC.
Any precedent?
Your lordship?
Any precedent which defines obscenity?
Your lordship, obscenity was also defined again in the case I mentioned, which was the Qriae Abbas case. It was also defined
Not
in the
any time sooner by the Supreme Court?
Your lordship, it was also... Your lordship, obscenity is a very grey word. It differs from every case to case. So the definition of what is held to be obscene and what is obscene also changes with the case, but the major definition of obscenity is defined in the IPC. If the council has permission to proceed.
Yes,
And
please.
on the page 1 of our prop, we have defined obscenity as defined under IPC as well. We have quoted the IPC. If the researcher can please go to that. In the light of the case at hand, we can clearly see that the sale of sex toys raised several questions in the society it was being sold in. It was clearly against the morality and the cultural standards which were already set in the society. The courts have, while dealing whether a particular product is obscene or not,
So,
taken into
Counsel,
account.
before you proceed further, tell me, what are you against? Sale of sex toys in open market, or you are also against the sale of sex toys in e-commerce platforms?
Your Lordships, that is where we would like to draw a line that we are only against the sale, as mentioned under 292, we're against the public exhibition of sex
Why
toys.
on an e-commerce platform is there no public exhibition?
Your Lordship, even though that is, we are not trying to deny that there is a public exhibition there.
So how
But
can
what
you
we
create a class within a class? Is it not violative of 14 then?
Your Lordship, we are not creating a class within a class.
You are allowing the sale of the same item online, but you are banning the sale of the same item in physical market. What
Your
would I call
Lordships,
this?
Your Lordship, sale of it in physical markets
What is
would,
obscene online is obscene. What is obscene physically, and what is obscene physically is
Your
obscene.
Lordship, while dealing with products which are obscene, there are aspects which need to be considered, which is relating to the
as?
packaging, which is relating to the packaging of the item, the way it has been advertised, the
So you
way.
mean to say that on online e-commerce platforms, all these sex toys are showcased in a packaged form?
Your Lordship, that is not what I'm trying to portray. But
Then
what I'm trying to portray here is, yes, on these online e-commerce platforms, even though they're not portrayed in packagings, that is not the issue we are pertaining
don't
with.
you think the e-commerce has a larger interaction with the public domain than the physical shops?
Surely, Your Lordship, we are not denying the.
Then you can't
We
have
are
this
not.
mentality that you will allow something to be sold in a physical market, or you will not allow it in the physical market, but it can be allowed on an e-commerce platform. Sorry.
Your Lordships, for that, I would like to draw parallelism about how porn is not illegal in the country of India, but
Have we
porn CD
banned porn?
shops are illegal.
Have we banned pornography?
Your Lordship, same way, we are not banning sex toys. We are not banning the usage of sex toys. We are just simply trying to put a restriction here.
Can you watch porn in a physical market? It can be only viewed
Your
online,
Lordships,
in my opinion.
that is what we are. You can watch porn in a physical market, but you
How?
can't display porn in a physical place. If you're watching it in the confines of your
E-commerce is
own,
equally physical. Let me tell this to you. As a larger public interface, larger public interaction, the goods which are being depicted in a physical shop will be depicted in a similar fashion on an e-commerce platform. How can you say that I will allow such a thing to be sold online, but I cannot allow the same thing to be sold physically?
Your Lordship, what we are trying to put forward here is that even it was very well established in the case of Justice Puttaswamy against the Union of India that right to privacy is an integral part of Article 21, and so is the right to sexual privacy.
So,
And what we are trying to
right of
portray here
sale
is
of a sexual toy has nothing to do with the right to privacy of any individual.
no.
Unless
Your
and
Lordship,
until I don't reach the shop to buy it, how can I say that my right to privacy has been infringed?
No, Your Lordship, that's not the contention the council is trying to put forward. The contention the council is trying to put forward is that we are not trying to deny that the citizens of this country can use sex toys. What we are simply trying to put forward before this honorable court is that the sale of these sex toys in the specific place of beach town was against the morals and ethics of the community living there.
How
And
have
that
you
is why
ascertained that? How much is the population of Orthodox culture in the state of Beachtown? Do we have any statistical data to rely upon? Have you attached anything as a compendium?
Your Lordships, the Moot proposition is silent about this thing.
Even we will
But
not
what we are
presume
trying
people to be Orthodox there then.
Your
You
Lordship,
will
we are
not
not
presume
trying to
what
say
authority
that
do you have to appear before us. We will not presume the orthodoxity when the problem itself says, the Moot problem has been so categorically drafted. It says that the state of Beachtown has a interface of a younger crowd. So how can you say that the people living there were not happy with the sale of these items? Therefore, the ban is authentic.
Your Lordships, if you are so categorically referring to the
I
Moot
have to.
proposition, I would also like to point out this fact that Mr. Obituroy, it's been mentioned in the proposition, Mr. Obituroy assumed, he did not have any any fact or any, as you said, any data to analyze this. He assumed, he was under the
He
impression
may
that his right
assume
to
he's an
freedom
individual.
should not be violated.
He may assume. As a state, can you assume?
Your Lordships, what also we are trying to
As
put
a
forward
state,
is
can
that
you assume, madam? Please answer my questions categorically.
Your Lordships, that is why we are not assuming anything. We are just trying to put forward that the
Your
breach of
presumption does not make sense here when the problem itself says that his decision was guided by the fact that Beach Town has a freer society. The society is comparatively more free, and its dazzling beaches and vibrant nightlife are always swarming with a largely younger crowd.
Your Lordships, even though there's a largely younger crowd present in Beach Town,
Then how have you anticipated that the community standard in that area was not competent or was not comfortable with the sale of sex toys? Therefore, the ban is authentic.
Your Lordship, because it is also in the subsequent paragraph, it is also mentioned that the panchayat receives several complaints.
I believe
The council would like to request.
My seniors would want to hear you more in a matter where you have not even been put to notice on. I don't mind.
I think your second speaker can come up. Your time is already up.
Much.
The council seeks permission to approach the dais.
You may.
The council
You are
seeks
also an ASG with the state?
Your Lordship, I am the Solicitor General of the in the current matter. Much
You
obliged.
know, I'm a panel A counsel to the government of India, and if I tell Mehta Sahab that I have a younger version of him today, email, trust me.
Much obliged, Your Lordship.
Oh no. Please proceed.
The council seeks permission to begin with his pleadings, and the council also seeks permission to refer to the honourable judges as Your Lordships. Much obliged, Your Lordships. Good afternoon, honourable judges, Your Lordships. May it please the honourable court. I am the second speaker on behalf of the state, and with thus I would be addressing issue 2 of the current contentions which are being put forward by the respondents. The issue 2 will address that closing down Obituroy's shop was not violative of his fundamental right under Article 19, Clause 1, Subclause G, and thus the writ petition as filed should not be entertained in the honourable court.
That I think we were convinced.
Yes, Your Lordship.
The petition is not maintainable.
Yes, Your Lordship. So the council would just like to elaborate, since that aspect has been mentioned, the council would like to elaborate why the closing down of the shop was not
While the
violated.
written submissions, we'll read it at the time of passing a detailed order.
Sure, Your Lordship. The council just like...
We'll reserve the matter.
Pardon, Your Lordship?
I think we'll reserve the matter. You file a written submission, we'll hear you. We'll
Lordship.
write your observations in our order.
Your Lordship, while that is a completely ethical practice by the court, the council would still like to seek permission from the Lordship to proceed with the arguments.
Okay, please.
Much obliged, Your Lordships. Your Lordship, for this to substantiate the similar claim, the council would like to proceed with the threefold argument. The first limb of the argument as put forward by the council is that the restriction under Article 19(1)G was a reasonable restriction to the fundamental right. The second limb of the argument is that the necessities to file a writ petition were not fulfilled. However, this argument has been previously discussed in the court. The third and final limb of the argument is that there was no violation of such fundamental right, leading to no sufficient cause to file such a writ petition. With the discretion of the Lordships, the council would like to proceed with the arguments for subcontention 1.
Yeah, after subcontention 1, I'm sorry.
I'll repeat for Your Lordships. Your Lordships, the subcontention 1 is that the restriction under Article 19(1)G was a reasonable restriction to the fundamental right.
Achha, without issuing a notice, a show cause, an opportunity of even 72 hours to vacate a premises, which is the statutory mandate, how do you say that demolishing his property was a reasonable restriction?
Your Lordship, the council would like to, if it's in the power of the council would like to clarify on one situation. There was no demolition of shops which took place. The shop was shut down. Yes, Your Lordship, shut down.
Still, you have to give a notice for that.
Your Lordship, while that is the common practice, however, while the counsel would also explain it through certain case laws in his argument, the counsel would brief it up into 2 lines for the Lordship to write now. Your Lordship, while that is the extent of the evil which was sought to be removed in such a precedent case was of such nature that the shutting down of the store in the manner was necessary. Your Lordship, under section 69
we
of
want you
the...
to ban it online also then. If you are that orthodox, do it both ways.
Your Lordship, the counsel didn't get it.
We want you to ban it online too.
Your Lordship, while that is on the discretion of the court, the counsels here argue only for the subsequent shutdown of the physical sale of the
Can you
sex.
convince us that why selling the same thing online is allowed?
Your Lordship,
And without, and एक minute, question सुनिए पहले. Why, tell us a simple thing, that why selling the same toy on an e-commerce platform would not be violative of the reasonable restrictions under 19.2 and 19.6. And why would selling the same toy in a physical shop would attract the reasonable restrictions under 19.2 and 19.6?
Your Lordship, while that is a perfectly valid question, Your Lordship, the manner in which the sex toys were being sold in the physical store of Mr. Roberto Roy was extremely questionable. Your Lordship, there were signatures which were being put up even after the police, even after the individual who went into the store and came out with, Your Lordship, purple and orange batteried sex products. There was a clear representation of human genitals in the form of in public display. Your Lordship,
don't you think that?
Where do you get this in the facts?
Your Lordship, in the fact it has been mentioned, and I quote that. Your Lordship, in the facts it's mentioned that there was a purple sex toy and another sex toy with an orange battery attached to it.
That was 2013 incident. He has been convicted for that. Why are you repeating it here?
Your Lordship, there were even though the factual matrix is silent on
No. तब भैया ये तो गलत बात है फिर तो एसडी साहब ये गलत है. This is genuine double jeopardy.
Your Lordship,
इसके बाद आप उसके पुराने एंटीसीडेंट की बात एक नए मैटर में उठा रहे हैं. Sorry, will not have it.
That is perfectly fine, Your Lordship. That contention is perfectly fine as has been put forward by Your Lordship. However, Your Lordship, the counsel would just like to plead on the fact that even if we keep the aspect of the sale, the type in which they were selling the objects aside, Your Lordship, it is against the common cultural beliefs of the state at the moment that the physical sale of such goods is obscene to the extent that there were signatures and all which were attached to it. This was also in the current...
They were attached. So
no, Your Lordship. In 2023 they were attached.
Please refer to which para? Which para do you rely upon to say this?
Page 2 of the Moot proposition, paragraph 1. On page 2. Your Lordship, the Panchayat took action against the shop, removing even the signage.
Where? Please read the appropriate.
Your Lordship, I'll read it from Pongol Sarpanch. Mr. Namjoon said that they had received verbal complaints from many people about the shop and that it was against their culture, causing the shutdown.
This is a statement. Have you verified it?
Pardon, Your Lordship?
This is a statement by a Sarpanch. How do you take this as an evidence? As a compelling evidence.
Your Lordship, while I'm not taking it as a compelling evidence, Your Lordship, I'm merely putting forward the aspect that there were such signages which were attached to the shop, which had to be removed.
Signage could only be confined to his name. How do you assume that there were other sex toys displayed on the signage?
Your Lordship, while I'm not contending the fact that there were sex toys which were displayed on the signage, Your Lordship, it is a common understanding that providing advertisement for such sex toys in the public with signages and everything is to be considered obscene under section 292 of the Hindustani Penal Code. Your Lordship, furthermore, it was.
बताइए पुलिस किसकी सब्जेक्ट है? 7th शेड्यूल में पुलिस कहाँ आता है?
State, Your Lordship.
तो आप यूनियन बन के 292 स्टेट का आर्गुमेंट क्यों कर रहे हैं?
Your Lordship, while that is absolutely a perfect contention. That's what the union also. That's what the union was also very shocked. Your Lordship, the Solicitor General himself has a lot of cases lined up, and thus
you are appearing for states now.
Your Lordship, no. Your Lordship, that is a completely different contention.
Police, Chandigarh police, I can understand. Why are you appearing for Goa police?
Your Lordship, that is completely a different aspect. I am not appearing for Goa police. Your Lordship, I have been made a party to the petition, and even
you are saying that you have not been made a party.
Your Lordship, that is not on the respondents. That is something which the petitioners have goofed up on. Your Lordship, the respondents.
I take it.
Yes,
but again, again, why do we say that the petitioners have goofed up? They may
Your
not have wanted to make the union a party.
Exactly, Your Lordship. While that is a perfectly valid question, and in an ideal scenario, had the state also been a party, and there would have been some differences in the facts. Your Lordship, there was a closure of such sex toy markets in in many other states in the union. Your Lordship, this had even though Mr. Obito Roy came to the court for his selfish and private reasons, Your Lordship, the matter at hand.
You have shut down his shop, khana pina band ho gaya, genuine.
Your Lordship, the way he was earning, while I completely understand the fact that his livelihood has been stopped.
Yeah.
Your Lordship, the way he was earning his livelihood was also illegal under the set provisions.
Mr. SG, did you follow the due process of law for shutting his shop? Was he given a right of hearing? Was he given a notice? Or is it a high-handedness of a state concern?
Your Lordship, such a nature, on such aspects, the factual matrix is silent, and thus the council can't comment on that, comment on information which has not been provided.
But SG साहब आप ये क्यों कह रहे हैं कि sale of sex toys is illegal?
No, Your Lordship, that's not what I'm contending.
अभी तो आपने बोला.
Your Lordship, public sale and display of sex toys is illegal. Your Lordship, online platforms, as many sex toys as any individual wants to buy, sell, is allowed.
Online e-commerce has a wider interaction to public at large.
Your Lordship, while that is a completely valid inference.
फिर तो वो तो class within class हो गया ना?
No, Your Lordship, selling pornography CDs in the public and watching porn on online platforms is two completely different contentions. It's not a class within a class. Your Lordship, merely providing for the banning of sex toys being displayed and sold publicly is completely a different aspect than selling sex toys on an e-commerce platform. Your Lordship, currently in e-commerce platforms, sex toys are not being called sex toys. They're being called massagers or vibrators and many other such different aspects. They're not being sold.
तो क्या physically इनको sex toy लिख रहे हैं हम?
Yes, Your Lordship, that has been mentioned.
कहाँ पर? दिखाइए पैरा.
Proposition पे, Your Lordship, not once in the proposition has it been mentioned that the sex toys were called anything other than the sex toys.
Again, yeah, but how can you say that because the contrary has not been mentioned, therefore you cannot say the other side has to be construed as is.
Your Lordship, that can also be valid inference on the side of the
response. Inference is valid, but as a state, can you just rely upon mere inferences?
Your Lordship, while that is a completely valid argument, even though the state has to...
I am a judge, why will I argue with you, yeah?
No, Your Lordship, the council is not up to the power of the Lordships to argue with Your Lordship. The council merely seeks guidance, and the council merely is here to argue his own matter.
Trying your level best, let me tell this to you. That effort to play around, I think it's working really well.
Much obliged. Your Lordship, Your Lordships, while coming on to the aspect of why they're allowed to be sold on e-commerce platforms, Your Lordships, the court, or neither the court nor the statutes can intervene in the matters of the individual. Your Lordship, such was also held in the case of Navteej Singh Jowar, which had been passed in a different aspect. Your Lordship, furthermore, while coming into the aspect of intervening into the privacy matter, Your Lordship, selling the sex toys publicly is something which is not a private matter altogether. Your Lordship, if an individual is buying a sex toy, getting it delivered to his home in a very discreet manner, in discreet packagings and brown boxes and everything else, that is a very different aspect altogether. While an individual is going to a sex store and buying such a sex toy store and buying such products in the open public in a state like Beachtown, which is already very vibrant and full of tourists.
My Chief Justice passed an order legalizing the same-sex couples to stay together.
Yes, Your Lordship.
Yes, in a city like Delhi, where I am sitting right now, we have the Central Delhi University, where saal mein Pride Parade and whatnot happens.
Yes, Your Lordships.
The society is evolving. If these things can be sold online, they can be sold offline.
Your Lordship, that is a completely different inference. We cannot compare the aspect of bringing in the LGBTQ community and
No, I'm not bringing that. I'm saying the progression. Earlier, what was not allowed is being recognized as a right now.
Yes, Your Lordship.
I have a question here. Suppose in a vending means there had been a condom vending machine, and one vending machine was long back installed in the Delhi University area. So was it not amounting to obscenity?
Your Lordship,
because it is talking something relating to sex. So means when we are relating the aspect of sex with the obscenity, and on which basis the entire world is moving, means how far can we take this, that selling a condom through a vending machine in the open arena where people will put coin inside it and then it will come out, So how means when it will not amount as a obscenity, then how could the very fraction of selling the sex toys in a public domain will amount to be obscenity?
Your Lordship, the council is very glad the argument of condoms was brought up in the situation. Your Lordship, the advertisements, the mere advertisements of condoms on any platform whatsoever, offline, online, has been banned from 10 p.m. to 6 a.m. in a 2017 judgment.
But not the vending machine by inserting money.
Lordship,
That has not been banned from 10 p.m.
This is not an advertisement. This is a shop we are talking about.
Yes, Your Lordships. Your Lordships, vending machines also, condoms are not provided in the shapes of human genitals, Your Lordship.
अरे भाई आप एंट्री करके उसमें सिस्टम पे पैसे डालते हो और कॉन्डम लेके जाते हो, इससे ज्यादा क्या चाहिए आपको?
Your Lordship, they're not in the shape of human genitals and everything. Your Lordship, Section 292 of the Hindustani Penal Code, as mentioned in the Moot prop, provides that exhibition of genitals in the form of sex toys meant for sexual activities falls under the definition of obscenity.
Then let us have the community standard test. That is why I was taking you to the same-sex marriage and progression of the society.
Very glad, Your Lordship. The council is very glad that the community standards test has been brought up. Your Lordship,
even if community standard, post-Avik Sarkar.
Pardon, Your Lordship.
Post-Avik Sarkar I am talking. I am not talking about the Ranjit, the Udeshi matter. Hicklin has been done away with. Avik Sarkar says the changing norms in the society ought to be compared vis-a-vis the act being alleged to be obscene.
Yes, Your Lordship.
Right?
Yes, Your Lordship.
There is a Kerala High Court judgment of last year on this. A woman...
Yeah, Your Lordship. The council is well versed.
Her child was painting her. And she recorded a video of it. The Kerala High Court did not hold it to be obscene.
Exactly, Your Lordship.
Mr. SG, have you been to Khajuraho temples?
Your Lordship, I think that Your Lordship, sex toys, what the council here is arguing is that, Your Lordship, even if we take into the community standards test and we take into the consideration the ever-changing morals and ethics of the community, Your Lordship, even I, on behalf of the government, I'm contending that the government is giving rise to sexual health awareness and other such education-related activities.
Aur becho na yaar.
Your Lordship, selling sex toys does not promote education, Your Lordship.
You are right now talking about sexual wellness. तो उसमें तो sex toy का काम आएगा.
Your Lordship, that is also a completely different argument. Your Lordship, how is selling sex toys and using sex toys related to sexual wellness?
That is the question. Who are we to decide what would lead to what wellness or what unwellness for anybody as a state?
Exactly the contention of the council, Your Lordship. We are not banning sex toys, Your Lordship. An individual has to use XYZ individual has to use a sex toy. They may use a sex toy. We are banning the mere public sale and display of the sex toys.
What do you think that people outside these physical shops would create a ruckus for the people who would come to buy these sex toys? Is that your argument?
Your Lordship,
it may lead to promotion of more crimes against women, things like
Your Lordship, that can also be a valid conclusion of the same. Your Lordship, selling human genitals in the public can directly...
We are not selling human genitals here. We are selling a toy in the form of a human.
Your Lordship, toy in the form of apologies from the council side. Toy in the form of human genitals, Your Lordship. That can also lead to even more crimes, which lead to women and children. Your Lordship, the current aspects of even the Bharatiya Nyaya Sanhita and everything, that all it is trying to do is decrease the crimes against the women. Your Lordship, such sex toys being sold and displayed in the public gives rise to the prurient interests of the individuals. Your Lordship, selling such sex toys in vibrant places like
where we have started giving hotels to unmarried couples and hotels are being booked hourly basis, and see the progression of the society again.
Your Lordship, even though that is true, Your Lordship, still there is an existing taboo. Your Lordship, if an XYZ person a condom falls out of his pocket, he will still be embarrassed to pick it up. Your Lordship, that does not relate to the aspect
that depends from person to person. What if he is selling condoms? Why will he be embarrassed to pick it up?
Your Lordship, all I'm trying to, all the council is coming ahead is there is an existing taboo regarding the same in the entire nation.
So as a state, why are we considering that a taboo than the policies and laws at hand?
Your Lordship, a taboo directly relates to the culture which is prevalent in the state. Your Lordship,
is taboo a source of law?
Your Lordship, neither is culture. However, Your Lordship,
culture and customs are.
Your Lordship, culture and customs, even though
customs are protected under Article 25.
Yes, Your Lordship. Your Lordship, a taboo gives rise to the culture. Your Lordship, a taboo is a part of the culture.
Established practices are protected. Well, nonetheless, I think we can close it down from here.
Your Lordship, the council would just like the remaining time. I think the council has 2 minutes remaining of his oral
ऐसे सब
argument.
बहुत matters हैं.
Close it down.
Please focus there.
May the council conclude his arguments?
Yes.
Much obliged, Your Lordships. Your Lordships, with the aforementioned aspects that the council has brought up, and if it pleases the honourable court, the council would request Your Lordships to kindly move on to the prayer of the respondents.
Just mention it.
Yeah, much obliged.
Share the screen. Come to the last page.
Okay, Your Lordships, come to the last. And may the council read out the prayer?
Yeah, please. Don't start.
No, Your Lordships, the prayer is a very respectful.
Because we are not allowing it.
Your Lordships, I think that is on the discretion of the honourable court. The council is the best to persuade. Wherefore, in the light of the facts stated, issues raised, authorities cited, and arguments advanced, it is most humbly impugned before the honourable court that it may be pleased to adjudicate and declare that, firstly, the sale of sex toys by Mr. Obito Roy was violative of Section 292 of the Indus.
हम कैसे कर सकते हैं? एक second. We can declare an act to be violative of a fundamental right. How can we declare an act to be violative of a penal provision?
Your Lordship, the act can. Your Lordship,
could have written hold the sale of sex toys being violative of the reasonable restrictions under 19.2 and 19.6. How can we say that it is violative of 292?
Your Lordship, it doesn't conform to the statute which is mentioned under 292. Thus, it violates the.
Can we pass an act saying that you have committed an offence under 292?
No act, Your Lordship. The mere direction of the order. Pardon, Your Lordship?
Can we, as the Supreme Court sitting here today, declare that the act of the petitioner is an offence under 292?
Yes, Your Lordship.
Without a trial.
Without a trial?
Not without a trial, Your Lordship. The council prays and will further pray that the Supreme Court may pass any such directions which it may deem fit in the nature of justice, equity, and good conscience, and for the same acts of kindness, the council on behalf of the respondents shall duty bound forever pray, Your Lordships.
Right. Thank you.
Much obliged, Your Lordships. Much obliged.
Rebuttal allow kare, sir?
Yes, sir. There is a rebuttal if judges permits.
My seniors have to take a call on that. Sir, आप mute है, sir. Vivek, sir, आप mute है, sir.
2 minutes each, I think.
Right, sir.
Not too much because we have already discussed too much.
Right, sir. Right, sir.
Your Lordship, permission to begin?
Yes, sir.
Yes, please.
Your Lordship, we have kept 6 minutes as reservation for the rebuttal round as per the distribution of the
Close it in
time.
2 minutes.
2 minutes. My senior wants it for 2 minutes. Let us have it for 2 minutes.
Yes, Your Lordship. For Your Lordship, if I could just share the submission made by the respondents party on the screen. If you would like to show certain things, pointing out certain paths to the honorable bench.
My seniors have to take a call.
Your Lordships.
Yes, carry.
Proceed.
If you could share the screen and go to page 6 of issue 2 of the submission of the respondents. Your Lordship, if you could read just the title of the submission made, closing down Mr. Obito Roy's shop was violative of his fundamental right under Article 19(1)(g), and thus the writ petition should be entertained. This is the submission that is made by the respondent themselves, Your Lordship. Furthermore, Your Lordship, I would like to...
I had a wrong typist, I believe.
Your Lordship, this is the submission made before the court. And even further, there are more points I would like to highlight, Your Lordship.
We are very happy to see these things, okay? As counsels, हम भी यही करते हैं आपस में.
Your Lordship, furthermore, if you
Clerical
move
mistakes.
Your Lordship, if you move on to point 45 in the same issue. Point 45 mentions, thus with the explanations as mentioned, the respondents humbly submit that the necessities to file a writ petition are fulfilled, contended by the respondents themselves, Your Lordship. Your Lordship is satisfied. Furthermore, Your Lordship, they have highlighted about the fact that sexual wellness, this product does not contribute to any health aspect or sexual wellness. I would like to put forward the point about the Section 22 of the HIV Act 2017, which mentions that any, notwithstanding anything contained in the law, it has been mentioned in our memorial. We have mentioned that the section states that any strategy or mechanism or technique adopted or implemented for reducing the risk of HIV transmission or any act thereto carried on by any persons, establishment, organizations in any manner as directed shall not be restricted or prohibited in any manner and shall not amount to criminal offence, Your Lordship. Furthermore, Your Lordship,
do you want to say that you were selling sex toys to prevent HIV?
Your Lordship, we are contending that selling of this products does not directly lead to obscenity, Your Lordship, because of the very fact. Firstly, we were operating through a brick and mortar shop and not publicly displaying these products on the road. And second of all, these products directly have a relation to promoting the general public health at large, Your Lordship.
No, we will not take that argument.
Your Lordship, in the same provision in point 2, it has been mentioned that the provision of use of safer.
What about those people who want it for self-satisfaction, who have no intention of having sex with any third gender or a third party per se?
Your Lordship, that falls within their right to privacy. What they're doing within their own four walls.
That is why it is not a case of promoting sexual wellness or medical aspects.
Your Lordship, we are just contending the fact that this products not only enhances the sexual pleasure of a person but also has health-related benefits attached to it, Your Lordship.
No. It may have it, but if you are rooting your entire argument on sexual wellness and medical aspects, let me tell you, you have not set up a shop upon an approval by the Medical Council of India specifically allowing you to sell these sex toys to people who are affected by HIV. Therefore, this argument will hold no value whatsoever.
Your Lordship, these products adheres to as and when the need arises, Your Lordship. For example,
please do not bring it to the health ground. You are going on a wrong footing.
Your Lordship, furthermore,
any other argument you have?
Yes, Your Lordship. Yes, Your Lordship. I would just like to point out a few more points, Your Lordship. The respondents.
Just 2 more points. Choose your best 2 points and then mention.
Yes, Your Lordship. The respondents, firstly, themselves have mentioned that they have contradicted themselves. First, they have mentioned that there are explicit legislation that bars the sale of sex toys, which is not there as of now in the Hindustan. And second of all,
we have pointed out to them. There is no illegality in sale of.
Yes, Your Lordship. And furthermore, if the same was held by them, why were we allowed to open up a shop in the first place? The shop was operating for a whole month, Your Lordship. No action was taken.
Appellate body, please.
Your Lordship, and furthermore, I would like to also highlight that the respondents have drawn on extraneous facts again and again to substantiate their points, because there are very many facts in the submissions made by them. As we are short of time, I'm not.
So oral arguments are done.
Yes, Your Lordship, and only the last thing I would like to mention is that they have mentioned Ranjit Udeshi as and when they have not stick to a proper judgment. They are themselves saying that they are following the community standard test, and then they themselves have mentioned the Ranjit Udeshi judgment to satisfy their arguments. And as and when their arguments plead says, they have used the same judgment.
Ranjit Udeshi is no more the law.
Yes, Your Lordship, it has been mentioned by the respondents themselves in the submission, Your Lordship.
We have not taken that submission.
Yes, Your Lordship, they have mentioned it in their
side. We will hear now.
Sorry, but
from respondent side, who will take it?
Your Lordships, if approach the court, and if the council may get
just continue here.
Just 30 seconds to share the screen.
Mm-hmm.
Yeah.
Do you really have anything to rebut?
Your Lordships, we would just like to point out on some things which were presumed by the opposition counsel in their written submissions, as they did not. If the court would allow us just 2 minutes, if the court doesn't want that, then the counsel
take 3 pointers.
Okay.
And only in
both the petitioner and respondents must be thankful. We have been giving a lot of time to both of you to prove your points.
I would
time, but please be thorough and be specific. This is a sir rebuttal. Pointers boliye, khatam kariye.
Yes, Your Lordship. Your Lordship, I would request my researcher to kindly go to page 18. and in page 18, last paragraph, it is clearly assumed by the opposition counsel that they had a license to operate. Throughout their memorial, if the honorable bench would read their memorial, they
What's
have.
your point? Just make your point.
Your Lordship, there was no concept of a license. What I would like to just bring up this one point is that if they have a detailed understanding of their memorial, they would see that throughout their memorial, they have assumed a lot of things and they have based their own the mere assumptions of the factual matrix.
All right, taken. What is this next point?
Your Lordship, now I would come to the health benefits point.
That is not applicable. We have already told them.
Okay, Your Lordship. Then
Yes.
this is the last point the council would like to mention, which is the highlighted paragraph, where the opposition council is trying to say that the sale of sex toys would help in decreasing population control.
यार उसको दुकान चलानी है कुछ तो बोलेगा. I
Your Lordship, I don't think the opposition is well versed with the.
Yeah, taken.
All right. Very good.
Much
So we
obliged.
can close it now.
Much obliged. Thank you.
Now we are back to the court masters. Huh? Now you carry on the further
Yes, Your
proceeding.
Lordship.
I think we can have the deliberation among us for 2-3